Hey everybody, how's it going? And welcome back to Copper Jacket News. So with the Supreme Court's recent decision and the language on these papers right here, we are looking at the end of assault weapons bans. Let's get to it. Hey, I want to thank everybody very much for watching these videos. Trust me, I really do appreciate it. If you haven't done so already, please hit that subscribe button. It's free. It only takes a second, but it helps me out quite a bit. And if you want to support this channel, support the main sponsor of this channel, which is the USCCA. The USCCA is 100% risk-free, but with your membership, you get things like self-defense, liability, insurance, which is, trust me, the best peace of mind that you could ever have in your wallet. Okay, so let's go and break this down real quick. Now, I'm kind of embarrassed that I had to read the Justice Thomas opinion in the NYSRPA V Bruen case 3 times before I got a really firm grasp on it. But the third time that I read it, I went through and I started really picking out sentences, lines, and paragraphs that had meaning for other 2A cases that we face in this country. Now, I saw a direct link between what Justice Thomas wrote and current assault weapons bans. Now, I have some snippets right here of text directly from his opinion, and I'm going to read you guys some of it that I feel is kind of relevant to that, because one thing that you hear all the time, I mean, it's almost like thrown in our faces, right? Well, when the Second Amendment was written, or it was ratified in 1791, the only thing that people had at that time were muskets, right? I'm sure you guys have all heard the same thing. That's what they had back then. They had muskets. There's no way that our forefathers could have ever possibly foreseen the future and what we have today. And so obviously the Second Amendment is only going to apply to muskets, right? Well, wrong. That's not actually the case, and Justice Thomas actually talks about it. So let me go ahead and read you paragraph 3, page 2 and 3 is where it continues. So I'm just going to read you this one quick paragraph, but it is very enlightening because it shows you how the courts are supposed to look at that exact fact. Okay, so the text is kind of small here, had to throw on my reading glasses, but again, what we're about to read here flies directly in the face of those people who say that the Second Amendment only applies to muskets. So bear with me if I bobble a little bit here, but paragraph 3, starting on page 2, it says, "The test that the court set forth in Heller and applies today requires courts to assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. Of course, the regulatory challenges posed by firearms today are not always the same as those that preoccupied the founders in 1791 or the Reconstruction generation in 1868, but the Constitution can and must apply to circumstances beyond those the founders specifically anticipated, even though its meaning is fixed according to the understanding of those who ratified it." Now, I got to be honest, I've probably read that paragraph like 20 times now. It gives me chills every single time. It is a powerful, powerful statement. And again, says that the founders of this country may not have been able to, conceive of what we have now, but that's irrelevant to the text and the history of the Second Amendment. So it just basically solidifies that it doesn't matter if it's a musket or something that's more modern. They both apply the same to the actual text of our Constitution. So I think most of us understand that our rights existed prior to the Constitution, but our Bill of Rights puts our rights in text, making them enforceable. And so this document right here says that we have a right to modern arms. Well, how does that affect the current, existing, and upcoming assault weapons bans? Well, for that, you have to read Justice Thomas's opinion a little bit further, where he talks about how the lower courts are supposed to adjudicate cases that involve our rights. So basically what he said is that you can no longer use a two-step approach, which is what they like to do in the past, using government interests and so forth. You have to look at text and history. But he didn't just say to the lower courts, you have to use text and history, good luck. No, he actually specified and outlined the history that he's specifically talking about, so a time frame. He said that between the ratification of the Second Amendment in 1791 to the Reconstruction era in the 1860s, between that time frame, you have to find something that basically gives you precedent to your case right now. So you have to find something that existed within that time frame that supports the regulation that you're trying to put forth. So for instance, if they're trying to ban a certain class of arms, the lower courts would have to go back within that time frame and look to see if there was a law that banned those types of arms. So they would have to go back and look at that time frame and see if an entire class of arms was banned between that time period. And they weren't. There was no class of arms that in general that was in common use for lawful purposes. There's no class that was banned in that time frame. None that I can find, at least, and to my knowledge, none that the justices could find either. So there's cases right now that are already challenging these types of bans. As a matter of fact, the Supreme Court sent one back down to the lower courts to have them look at it again. And there's more cases that are challenging these types of bans. Now, in order to validate what I just told you guys about the text and history, and to get a better understanding of exactly why these cases will win in the favor of the Constitution in courts, let me go ahead and read you just a couple more paragraphs if you'll bear with me. So Thomas says, today we decline to adopt that two-part approach, which is what the lower courts like to use in order to infringe our rights. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply point that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearms regulation. Only if a firearms regulation is consistent with this nation's historical tradition may a court conclude, that the individual's conduct falls outside the Second Amendment's unqualified command. And the last one that I'm going to read you here, because again, I find this fascinating. It says here, despite the popularity of this two-step approach, it is one step too many. Another one that kind of just gives me chills. Step one of the predominant framework, which is kind of what I just read, is broadly consistent with Heller, which demands the test rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support applying means scrutiny in the Second Amendment context. Instead, the government must affirmatively prove that its firearms regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. Now, like I said before, I had to read that a few times myself to really understand exactly what it meant, but once I did, I understood that this is pretty much the end of gun control as we know it. Now, that's not going to mean the end of regulations. There's still going to be regulations, but as far as the big stuff is concerned, I'm pretty sure that this particular decision, the NYSRPA V Bruen decision, does put an end to everything major. So we just need to get those cases in front of the courts and have the courts apply the rules that were set forth by the Supreme Court. If that happens, you're going to see a lot of stuff be overturned within, I don't know, the next couple of years. It could be a lot sooner, given the fact that the Supreme Court actually sent a couple cases back to the lower courts to say, hey, we have these new rules. You need to go by these. Take another look and, try again, basically. So we could see something very soon. But I think over the next couple of years, you're just going to see a steady decline of a lot of what we've been seeing over the past couple decades. So fingers crossed on this one. I want to thank you all very much for watching. I really do appreciate everything. Thank you for the thumbs up. Thank you for subscribing. Thank you for watching. You guys have a great day.